Hi, this is a presentation on the ins and outs of probate for genealogists. This is the first of a series of 9 presentations that will be recorded and put on the BYU Family History Library YouTube channel. First of all, we need to ask, what is a probate? A probate is a set of court or government procedures established for the orderly transfer of property from a deceased to his or her heirs and or assigns. Okay, now we've probably already encountered a few words that are either unfamiliar or have meanings different than those that you would commonly assume. This, of course, is a problem that we need to address in all legal issues having to do with genealogical research. Later on, I will explain how to solve this problem, but right now what we're going to do is go ahead and address some of the issues and proceed with some of the definitions. The first question that needs to be asked is, why do we care about probate if we're genealogists? The reason is quite simple. The records kept in the course of a probate action are extremely valuable for establishing information about the deceased and the deceased's family. Some of the reasons why we would investigate probate files include the fact that they help to identify family members. These records may also give the wife's maiden name if that's unknown. Probate records can establish the relative economic status of the family. The records may also reveal unknown family relationships. A probate record may be the only record of the ancestor's death. It is not unusual that the date of death is unrecorded except in a probate action. Now, there's a lot of documents that can be found in a probate file. The file is the physical place where the documents were kept by the court hearing the probate. So when we refer to a probate file, we're referring to the collection of records that made up that particular court proceeding. The first is a will. We'll talk more about wills, but basically this is a document transferring that the deceased makes during his lifetime or her lifetime, telling how they want the property distributed. There are bonds. Those who act on behalf of the decedent's estate, administrators or executors or personal representatives, are frequently required to post a bond to ensure that the property will not be stolen from the heirs. There are various documents called petitions. In fact, a probate action is started by a petition. If there were a will, it would be a testate case, and a petition to probate the will would be filed. It could be called many things, but it starts out the probate action. There could also be a petition in the case of where there's no will, an intestate estate. In that case, there could be a petition for the issuance of letters of administration. This would be the way of starting a case without a will. There could be various accountings. The accounting could occur at the end of the probate, or it might occur in the middle of or during the probate. The accountings are reports that are given by those who are administrating or executing the estate to the court, letting them know the status of the estate or what is going on. Could be an inventory, or multiple inventories depending on the amount of property owned by the deceased. These are very valuable documents because they give an insight into the life of the deceased and his family and his or her family. An inventory could be as specific as looking at each tiny item of personal property, one pin, a teaspoon, 2 saddles, a bridle, things of that nature. This is common in estates many years ago, more than 100 years ago. More current estates, you may find that personal property is all lumped into one statement saying something like personal property in the amount of $10,000 or something of that, like that. There are and probably will be different orders. An order is a decision by the court or the judge about how the probate should be conducted. Orders to set hearings, orders to provide information, orders back and forth telling the administrator or executor what to do. Decrees are generally formal statements made by the judge requiring a piece of property to be issued to the heirs or to some other person. A piece of property such as a house or a farm or other land or titled property probably would also be subject to what's called a deed of distribution. These deeds are recorded just like any other property deeds in the county, usually the county recorder or other recording entity. A deed of distribution is valuable because those who are researching, genealogists who are looking for probates, can do so by searching in the land and property records for deeds of distribution, administrators or executor deeds. When you find such a document, it will tell the court and the time period when the probate was filed, and is valuable in locating a document that would be otherwise locating a probate file that would be otherwise difficult to identify. One of the basic limitations of probate is that if there's no property, there's no probate. This isn't exactly true in all cases. More recently, for example, people were required to file a probate action only if they had property of a certain value. Anciently, in the distant past, over 100 to 200 years ago or more, probate were required even when people had very little personal property. So you're likely to find inventories like the one I mentioned where very small personal items are noted. Now you may be wondering, what is an estate? It seems like everybody would know the answer to that, but it is actually a legal issue. The laws must recognize an individual's property rights in order for there to be an estate. Anciently, or in countries where property rights are not recognized, there are no probates. An individual must have the right to alienate or transfer property to a spouse or others after death. Not only can there have to be individual property rights, but the right to transfer. The word to alienate here means to transfer or sell. And everything owned by the deceased at the time of death is in the estate. Many times when I was talking to people who were coming to me for a probate action, I would say that they needed to probate the person's estate, and they would say, well, we didn't have an estate. She didn't have an estate. My answer is, did she own clothes? Yes. Did she own kitchen utensils? Yes. Did she have a TV? Yes. Well, then she added an estate, but the question is whether or not the estate has to be probated. So any property owned becomes part of a person's estate. Now, who are the heirs? The heirs are those persons entitled to inherit the deceased's property. There are various ways that states consider whether or not a person is an heir. In addition, they determine whether or not and where a particular probate action needs to be filed. This is called the jurisdiction. Which court can hear the probate action, or which court can consider the probate action. First, that is established by the law, the place where the death occurs, or, and this is an or, a very important or, the place where the property is located, or, another important or, the place where the deceased resided at the time of death. Or lastly, by a will or other testamentary document. Each of these places would be considered by a court and whether or not it would accept a probate. One of the most important one is the second one there, the place where the property is located. If, for example, I had property in more than one state, I would have to probate that property in each of those states. I would file a main or principal probate action, and then I would have to file, if I were the heir or personal representative or executor of the estate, I would have to file ancillary or supplementary probate actions in each state where property was located. Where do I go to learn the language of probate and the language of the law? The basic book is Black's Law Dictionary. Black's Law Dictionary has been published for around 100 years, and a whole lot of editions. If you were to go out and try to buy a paper copy, you'd probably pay $100 or more for a paper copy of the book. But it's important to know that the book is online or in print. So you can see, if you go online and search, for example, a website called archive.org, archive.org, has a complete copy of Black's Law Dictionary 7th edition. Completely searchable, every word. Or you could simply go search for Black's Law Dictionary and find lots and lots of websites that define legal terms online. In addition, you could go to Google search, type the word define, leave a space, and put in the word that you don't know, and then Google will look up the meaning of the word. So it's very important to understand every word in a legal document. If you don't understand the word, you need to look it up. Now this went for me. I still had a copy of Black's Law Dictionary sitting on my desk or on my credenza behind my desk after nearly 40 years of legal practice. Now the question is, what is a will? A will is a document created by a person before death that attempts to influence the distribution of that person's property after death. The operative words here are attempts to influence. Most people consider a will to be enforceable, meaning you have to abide by the provisions of the will. However, that isn't always the case, and in fact, I would guess that only about 80% of the cases that I had through probate followed the will exactly. There were at least 20% or so where the will was either held to be invalid, disregarded, or changed by the court for some reason or another. So a will, in a sense, is a wish list on the part of the deceased, but usually used as a guideline for distributing the property after death. Important to understand the requirements for a will. A will must conform to the legal restrictions in force at the time the will is made. Now, this means that it might take some research to find out exactly what legal restrictions there were on the making of a will historically. That kind of information is generally available. We often think that genealogists want to know about these documents, but we fail to realize that the real reason these documents are preserved is because the attorneys and lawyers all want to refer to them. They're important legal documents and are maintained independent of any research interest we might have. Secondly, And in most jurisdictions, uniformly, the will has to be in writing and witnessed, or must be in the handwriting of the deceased. This is called a holographic will. Or it can be oral if it's witnessed and written down at the time or shortly thereafter the person dies. So this last one is called a deathbed will. And the court is going to look at each one of these types of will to see whether or not they are legally sufficient. That means, do they conform to what is required to create a will in the first place? If we look at the elements of a will, we'll see that they also depend on the law of the jurisdiction where the will was made. That's the place where the will was made. In most cases, the will must refer to or list assets. Now, this could be something general like, I leave all of my personal property owned by me at the time of my death. One of the other things that go into the making of a will is the evidence of what's called a testamentary intent. The person who is making the document needs to have the intent to distribute the property upon their death, and that needs to be put in the will. These elements help to identify whether or not that was the deceased's wishes. The will must also identify the beneficiaries, those who are to receive the property. Must name an executor or personal representative. As I listed, there's also a term called executrix and administratrix. These are female names, and in some places they are still used. A will must be signed and witnessed. This is almost a universal provision for wills, but there are exceptions. Thanks for watching. This concludes the first segment. There will be 8 more in this series, so stay tuned for additional information about genealogists and their use of probate records.